A seatbelt stop by an Oklahoma County sheriff shows why seatbelt stops are unlawful. Seatbelt stops violate the 4th and 14th Amendments. On February 23, 2013, at about 12 p.m. near the location of 63rd and Kelly, defendant was stopped by Sheriff Marshall, a law enforcement officer, for not wearing a seatbelt, and was written a citation for failure to wear seatbelt, in violation of 47 OS 12-417A. The officer was without any probable cause to stop defendant. Defendant has the right to not wear a seatbelt because of a disability, and he has the right to not be discriminated against because of his disability. All evidence obtained as a result of this illegal stop must be suppressed as a matter of law. The sheriff lacks probable cause because he has no idea of whether or not the driver is violating the law. The driver is exempt from the seatbelt law because of a disability. The stop was based on a hunch. Stops must be based on specific and articulable facts, taken together with rational inferences from those facts. A person in the same circumstances couldn't reasonably believe he had been, was, or was about to be engaged in a crime.
The key fact that must be considered is that some people do not have to wear seatbelts. Cannot reasonably suspect that a person driving without a seatbelt is breaking the law, since many people don't have to follow that law.
The Commissioner of Public Safety, upon application from a person who, for medical reasons, is unable to wear a seatbelt, may issue to the person an exemption from the seatbelt law. The exemption is in the form of a restriction appearing on the driver's license. Police can investigate crimes, but they cannot stop people to investigate whether or not a crime is being committed. They have to see an observed violation of the law. Not wearing a seatbelt is not always a violation of the law. It should not be a primary offense since some people do not have to wear a seatbelt. He did not witness a violation of the law. Police can't stop people to check their papers. Read the Supreme Court case of Delaware v. Prowse. If it needs to be a law, then it should be enforced as a secondary offense. To act like the rights of those that don't have to wear seatbelts don't matter is ridiculous. To act like we need to be babysat by cops and stopped for something that is not hurting anyone is ridiculous. The officer seized the evidence in violation of defendant's Fourth Amendment rights as his reasoning for seizure is fatally defective in establishing probable cause. It is a violation of the Oklahoma law to drive a car without a license. It is not a crime to drive a car with a proper license. It is the law of the land as spelled out by the Supreme Court that, even though it may be an offense to drive a car without a license, an officer cannot stop someone they see driving a car just to see if they are properly licensed. It is a violation of Oklahoma law to drive or ride in the front seat of an automobile without wearing a seatbelt without a proper license restriction on your driver's license. It is not a crime to drive or ride in a car without a seatbelt if you have a restriction on your license that gives you that right to do so. Based on Supreme Court rulings, an officer cannot stop someone they see driving or riding without a seatbelt on to see if they are properly licensed to do so. Stopping an automobile and detaining the driver in order to check his driver's license and registration of his automobile is unreasonable under the Fourth Amendment. See Delaware v. Prowse 440 U.S. 648 1979 U.S. Supreme Court.